Before we jump into today's courtroom drama, here's why this hearing is far more serious than it looks. At first glance, it seems like the entire case revolves around a single text message about a child spending the 4th of July weekend with one parent. But don't let that fool you. This isn't really about holiday plans. It's about whether that one message crossed a legal line and violated a judge's direct no-contact order. One wrong decision could mean losing bond privileges, being taken straight to jail, or facing even harsher consequences before trial. As the judge begins asking questions, you'll see confusion over family relationships, custody arrangements, and multiple court orders slowly turn into one critical legal question. Was this an innocent parenting update? Or a clear violation of the court's authority? Stay with us, because the judge's reaction later in this hearing completely changes the stakes.
Now, this is the one I was actually calling in on. Destiny Danier Henry, 26W842495. I'd like the victim in here. I have arraigned, Mr. Carmen, your name again?
Michael Lee Carmen, P7384. That's the defendant, Your Honor.
Ma'am, your name?
Destiny.
And ma'am, your name
Michelle, son.
and your appearances?
Jessica O'Donnell on behalf of probation.
William York, I have the paperwork.
So, Mr. Carmen has advised me that his client wishes to have a hearing. So I'm going to go ahead and swear in the victim as well as Ms. O'Donnell. And we'll go from there. Both of you raise your right hands, please. Do solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ms. O'Donnell?
Yes, sir.
Ms. Newsom? All right. John, why don't you take that garbage can over there for her, please? I'm going to ask you to throw your gum in there, please. All right. I don't care how we start. You can go ahead and start.
I have one bond violation I issued on June 22nd. My one bond violation is failed to refrain from having any contact, direct or indirect, with Michelle Newsom. I was contacted not only by the victim, but by the detective on the case for Woodhaven PD regarding that Destiny, Miss Henry, had contacted the victim via text message. The text message is from an iCloud account that I do have, that I do know is Miss Henry's account, because she communicates with me through that account. It looks like she sent a text message to the victim, Miss Newsom, June 21st. There's only one text message that was received. The text message relates to Miss Henry's child. It states that her son will be with me all July 4th weekend. That is the one text message. According to this, the no contact order states that she's not had any contact with her except through their family court proceedings. As of right now, there's no family court order in place. They have a hearing scheduled for July. The only court order that's in place, to my understanding, is regarding a Judge Hessen case. Miss Henry is also on probation with Judge Hessen for a domestic violence case. In that no contact order, Judge Hessen issued a no contact order stating that she's not to have any contact with her son's father, who is Jason Haney, who is the victim's son. It also states that the no contact order is to include their child custody should be done through third parties, meaning that Destiny's parents should be communicating with Miss Newsom and keep the parents out of the situation, that it's just the grandparents that should be communicating regarding the child's custody agreement. That's why I issued the violation regarding this.
I'm sorry, I'm a little confused about the relationships with everybody here.
Yes. So Miss Henry has a child with Jason Haney. They have a son together. Miss Newsom is the mother to Jason Haney. So she's the mother, she's the grandmother to Miss Henry's son.
And the content of that was, the child will be with me.
This is where the legal issue becomes much clearer. Notice that no one is arguing about whether the message was threatening or disrespectful. Instead, the focus is entirely on the existence of direct contact itself. In many criminal cases involving protective or no-contact orders, the court doesn't need an offensive message to find a violation. If the order prohibits direct communication, even a seemingly harmless text about child custody can become a legal problem. The prosecution is also emphasizing that there were already approved third parties available to handle these conversations, making the direct message much harder to justify. What do you think? Should courts treat every direct contact as a violation regardless of intent? Or should the purpose of the message matter?
July 4th, yeah.
July 4th.
That was the text message that was received, it was regarding her child. But again, as far as I'm aware, no contact order states that they're only to be communicating through third parties.
If I may, Judge,
Yes.
grandmother, so to speak, is the victim in the stalking case that is before his office.
That is correct.
Do you have any questions of Ms. O'Donnell, Mr. Kerman?
I would just ask, I believe you already said, Ms. O'Donnell, but there's one sole text message at issue.
That was the only one that I received from the victim. That's correct.
And it states, I believe, Deborah will be with me all July 4th weekend.
That's correct. It is regarding her child.
Said this was June 21st,
I'm sorry, let me double check. June 21st, it's
at 12:34 p.m.
yes.
No further questions.
Do you want to add anything, Ms. Newsom? I issued this bond, entered the bond, I should say, issued the bond on May the 27th. Is that the only contact that you've had?
Since that hearing, yes. Before, tons.
Right.
Since the hearing, just that.
Okay. Do you have any other questions, any other testimony, anything you'd like to say, ma'am?
I just want her to follow orders.
That short statement may end up being one of the most powerful moments in this entire hearing. The victim isn't asking the judge for punishment or revenge. She's simply telling the court that she wants the existing orders respected. From a legal standpoint, that matters because bond conditions are designed to prevent further contact and reduce the risk of additional conflict while a case is pending. The defense, however, is preparing to shift the focus toward child custody, arguing that the communication was connected to parenting responsibilities rather than harassment. This is exactly where many courtroom cases become complicated. One side sees a necessary custody update, while the other sees a direct violation of a judge's order. If you were sitting in the judge's chair, would you focus on the purpose of the message or the fact that contact happened at all? Let us know what you think.
Me and her mother is doing communications for custody. I do not want any contact with her.
Anything else?
Your Honor, I would ask Ms. Newsom, Deborah is my client's son, correct?
Correct.
And your son's son?
Yes.
Again, there's currently a proceedings for child custody in the Wayne County Circuit Court
Correct.
and just involving Deborah. Correct.
Yeah.
Okay, thank you.
Does your client wish to testify?
No.
All right, any argument at all?
Motion? No, does not wish to testify, Your Honor.
Any argument anybody have?
Your Honor, I would simply indicate that, I believe the court was clear. There is a highly functioning relationship between the two grandmothers. The other grandmother is in the back pew, if you could raise your hand.
Okay,
So the communication is highly effective to uphold any, what if any, parenting time the young lady wishes. She violated a court order. There was no reason, because there's no breach of communication between these two grandmothers. In essence, Judge, at least as far as looking after Devereaux, these two grandmothers are on the same team and they have his best interest at heart. The whole reason for being in court on this matter was the stalking for this young lady. So I believe this does beyond or by the standard of proof before the court for this, which is not guilty on a reasonable doubt. I believe it does constitute a violation, and I would ask the court to make such a finding and leave any sanction to the court's obvious discretion.
Your Honor, this is actually very simple. It's being made out to be more complicated than it needs to be. My client does have an ongoing case with Judge Heston. That's dealt with bringing up the courtroom. As far as in your courtroom, Your Honor, on the bond sheet, but you specifically wrote, with an exception to the no contact order, it's a little difficult to read the handwriting specifically, but I believe that it says, except in conjunction with custody proceedings in circuit.
In conjunction with circuit court proceedings.
Circuit court proceedings.
I think what I meant was, I know what I meant, is that if she runs into her in the circuit court, that's not going to be deemed a violation of the no contact. If there's something that happened in the order, I don't know exactly what the circuit court order was. Does the circuit court order provide for any kind of contact?
No, my son had told the circuit court that I did not want any contact with her because of prior instances, that I was willing to mediate for him since they couldn't do the mediation because of prior charges. So he said that I'm willing to speak with her mother and do communication exchanges. She agreed.
And just like that, the entire direction of the hearing changes. Up until this point, the defense had been trying to convince the court that the wording of the bond order created an exception because of the ongoing custody proceedings. But the judge makes something crystal clear. His interpretation of that exception is completely different. He's separating participation in court proceedings from initiating direct communication outside of court. That's a critical legal distinction. Judges often have broad authority to interpret the intent behind their own bond conditions. And once the judge states that interpretation on the record, the defense's argument loses significant momentum. The real question now isn't whether contact occurred. It clearly did. The only issue left is how severely the judge is going to respond. Will this remain a warning? Or is the defendant about to face immediate consequences for crossing the line? The answer is coming up next.
And that's just how that works.
Look, there is no question that you violated the no contact provision. You had no right to go direct her. No, I'm not going to violate your bond and lock you up for this, but I'm going to caution you. There's not to be any contact at all with these news. Do you understand that? Yes? I can't hear you. I find that you violated the no contact provision. You had no business having direct contact with her. So I'm telling you, if it happens again, I'm not going to hesitate to set a high bond. And you'll be sitting in jail awaiting trial on this. Do you fully and completely understand? I can't hear you.
So Your Honor, just for clarity, just for what you wrote on the bond sheet there.
Yeah, it says, except in conjunction with circuit court proceedings. This has nothing to do with a circuit court proceeding.
Well, I mean, my client indicated that to me it did because they had a circuit court proceeding scheduled on July 13th. She was just, I mean, it's custody, it's visitation.
But she's not a party to the circuit court proceeding. Miss Newsom here is not a party to that.
But my client has indicated that she's very involved.
It might, well, because I was saying, I know if I didn't say except in conjunction, except to effectuate visitation or custodial exchange with minor children. I did not say that. What I was saying with my except in conjunction with circuit court proceedings, goes and she's there, I'm not going to have somebody come in here and say she violated the no contact. She showed up, she was there, and the defendant was there. That's all I was trying to clarify.
I understand, and that's the clarification I was seeking.
I understand. But this young lady knew that. And I'm telling you, you're playing with fire. Do you understand what I'm telling you? I can't hear you.
This is one of those rulings that sends a powerful message without imposing the harshest possible punishment. The judge officially finds that the defendant violated the no-contact condition, but instead of immediately revoking the bond or ordering jail time, he chooses restraint. That's an important distinction. A bond violation doesn't automatically mean someone goes into custody. The judge has discretion to consider the seriousness of the conduct, the surrounding circumstances, and whether the defendant can still comply moving forward. However, make no mistake about it, this is not a victory for the defense. The violation is now part of the court record, and the judge has made it unmistakably clear that any future direct contact could result in a much higher bond or immediate incarceration. In other words, this hearing ends with a second chance, but it's a second chance that comes with an unmistakable warning. Do you think the judge struck the right balance? Or should the bond have been revoked immediately?
All right, so are you guys, I'm gonna find that there was a violation. I'm not gonna change the bond. I'll continue the bond. Are you guys going to go and try to pre-try this?
Yes, sir.
All right, good enough. That's what I'll do. And when you come back in front of me, maybe you're soft-spoken. We gotta pick you up. You gotta have your voice about 40 times the decibel level that you have it now, okay? Thank you very much.
Thank you.
Thank you.
What looked like a simple custody-related text ultimately became a courtroom lesson on how strictly judges expect their orders to be followed. Throughout this hearing, both sides agreed that only one text message had been sent. The real dispute wasn't about what the message said. It was about whether sending it directly violated a no-contact order that required communication to happen through approved third parties. After listening to testimony from law enforcement, the victim, and the defense, the judge concluded that the defendant did violate the bond conditions. Even so, he exercised his discretion by allowing the existing bond to remain in place instead of sending the defendant to jail. At the same time, he left absolutely no room for misunderstanding, warning that any future violation would likely result in a much harsher outcome. Cases like this are a reminder that in court, even actions that seem minor in everyday life can carry major legal consequences when a judge's order is involved. Protective orders and bond conditions are interpreted according to the court's language, not according to what a party personally believes is reasonable or harmless. That's why understanding exactly what a court order permits and what it prohibits is so important. Now we want to hear from you. Did the judge make the right decision by giving a warning instead of revoking the bond? Or should a no-contact order be enforced with zero tolerance regardless of the circumstances? Share your opinion in the comments below. We read them all and would love to hear your perspective. And if you found this courtroom breakdown informative and as fascinating as we did, don't forget to hit that like button, subscribe to the channel, and turn on notifications so you never miss another in-depth courtroom analysis. Thanks for watching, and we'll see you in the next case.